Hit it. Hey, good afternoon. I'm glad you're here. I'm glad somebody is here. There's nobody sitting in the room, so this is going to be a little bit stiff. I'm Tom Albritton. I'm the director of the State Ethics Commission, and today is training for lobbyists. So I appreciate those who are attending online. If you have any questions, please text those questions to the number that is behind me. What we will like to do is save questions until the very end, unless it's a question about a technical difficulty that you're having on your end, and if that is the case, then please let us know immediately so that we can attempt to correct it before we get too far into today's instruction. Remember that what I tell you today is the floor, it's not the ceiling. These are the bare minimum standards for ethical compliance, and you are certainly encouraged to go above and beyond what is technically required under the Act. There's certainly nothing wrong with going above and beyond what are the basics here. Nothing that we tell you here today has the same effect as a formal advisory opinion. This is simply general guidance only, and we request that if you have specific questions about whether conduct is permitted or excluded under the Act, that you ask us in the way that we will describe today. You can get answers to questions. That would be through either an informal opinion or a formal advisory opinion. I will also tell you that if you have questions, I think most of you already know this because you have dealt with her, but go to Vicki Manning. Vicki Manning is your person to talk to if you have questions about compliance under the Ethics Act. She is the first one to talk to. If you are asking a legal question, then what Vicki will do is forward that question to us, and our legal department here will handle answering the questions. But what Vicki is great about doing is, and what she can do herself, is answer questions about compliance with the technical requirements for lobbyists, that primarily being your registration and your disclosures. Our commission is made up of 5 individuals. They are appointed by the governor, lieutenant governor, and speaker of the House to serve staggered 5-year terms. If any of you are serving out of state, you will recognize this method of appointment as being pretty common in most jurisdictions. Our chair is behind me, and her name is Beverly Brady. She is a practicing lawyer in Auburn. She is currently in her last year of service with us, and she will be rolling off the commission after our meeting in a couple of weeks. Our second member of the commission and our vice chair is John Plunk. He is an attorney in Athens, Alabama, and he's about to begin his last year of service. We have Justice Lynn Stewart, former retired Chief Justice of the Alabama Supreme Court, who has been with us now for a couple of years, and she fortunately will be with us for a few more. We then have Stan McDonald, who is a lawyer in Huntsville, Alabama, and then our last commissioner is General Ed Crowell. This is General Crowell's second time to be on the commission. He is a retired brigadier general with the Air Force, also worked for a private contractor, lives here in Montgomery. He currently is the only non-lawyer we have serving on the commission. But they are our commission, and that's who I work for. But they are the 5 individuals who make all the official decisions for the commission. Everything that we've got in front of them that is official business, they are the ones who vote on it, and we're the staff that serves them. Let me skip over that. If you have questions about whether certain conduct is allowed or prohibited under the ethics law, you have a method available to you to get an answer to those questions. We as a staff can give informal advice, we can give informal opinions, and we give over 1,000 of those annually. An informal opinion is simply what you think it is. And again, if you practice in other jurisdictions, it is a very common method used by ethics commissions and other places to answer questions for you. Let's say you have a question about whether you can have a certain event and invite public officials or public employees to it, and you would like to cover their registration, and you would like to pay for certain meals for them in conjunction with the event. Those are questions that you can ask us ahead of time simply by emailing the commission and asking that question of us. That's called an informal opinion. An informal opinion does not give you protection from prosecution. A formal opinion does, however. A formal opinion is a formal document voted on by our commissioners, and in those opinions, they typically announce interpretations of the Code of Alabama that may not have been enunciated before or announced before. A formal advisory opinion will give you protection from prosecution. In the context of lobbyists and principals, we have very few formal advisory opinions, primarily because your functions and what regulates you is pretty well spelled out within the code itself. So there's not a ton of interpretation that comes down to what you have to disclose in your registration, for example. We have been asked questions by lobbyists and by the companies that employ lobbyists before, and you will find some advisory opinions that are relevant to you. One of them, just by way of example, and Cynthia will talk about it, our general counsel will talk about it when she comes to talk to you. But a couple of years ago, or I guess now it's been about 3 years ago, we had a question asked from the Business Council of Alabama about how to report expenditures for a large conference where you had a number of sponsors. And it gave us as a commission the opportunity to give guidance in this area. And basically what we said is that there are certain expenses that you can allocate among all participants. There are certain expenses that you have to disclose, but that opinion is out there. So the opinions that you will find that are relevant to what you do are generally reserved for those kind of issues, mainly reporting. We do have some opinions that talk about the definition of lobbying and who is a lobbyist. This is particularly helpful, I think, to people who may come into Alabama periodically and do some work with the legislature and are wondering whether we have some rule that requires us to quantify the amount of lobbying that you're doing before you satisfy the definition of lobbying. So we've talked about that. I will tell you, by way of a footnote, that Alabama does not have any kind of de minimis cutoff for lobbying. We really look at whether you're paid to influence the passage of legislation or administrative rules before a regulatory agency, and if you're doing that, then you're a lobbyist. But within that definition, there's still room for some definition, and I think we have done that in the advisory opinions. There are not a lot of them, so if you've got questions about what advisory opinions may apply to you, you are more than welcome to ask us what those opinions are, and we'll be happy to point you in the right direction. But that's the main distinction between the kind of advice we give, the informal kind that does not give you legal protection, or the formal advisory opinion that does give you protection. The way you ask for them is the same. You just email us and ask them. We do, and again, I don't know who's attending online, so I don't know what your background is. But in some states, you do have the ability to call the Ethics Commission and just get advice over the phone about some of these issues. We have an administrative rule that requires that any advice we give be in writing. So we have to receive your question in writing. We have to give you an answer in writing. I'm not trying to discourage you from calling us, and certainly call Vicki if you have questions about compliance. But if you're asking for an interpretation of the law, we're going to have to give that to you in writing. We're usually pretty good about getting that turned around quickly. But just talk to us about that and any time constraints that you may have. The advice we give you has got to be prospective in nature. You can't email us and ask us whether something you did 6 months ago was or was not a violation of the ethics laws. So think well ahead of time and formulate your questions before it's a problem. Our advice can only be prospective. Again, that's common. I'm not aware of an ethics commission that allows you to get absolved from conduct because you asked the question after the fact. I could be wrong about that, but I will tell you that by administrative rules, ours have to be prospective in nature. I'm going to go over briefly the enforcement process that we have here. The reason this is important to you is because the people you deal with will be public officials or public employees. And in the state, there are a lot of high-ranking public employees who you may have access to, especially if you are lobbying a regulatory body or a state agency, or you are trying to secure a contract at the state level of government. All of that can be considered lobbying, but you're probably going to be dealing with a public employee in that case. The public officials you'll be dealing with, probably for those of you who are dealing with public officials in a way that matters to the Ethics Act, you're going to be providing something to them. You're going to be providing a meal, or you're going to be inviting them to do something. So there are some restrictions that apply to you. There are limits as to what you can do. But let's just say that you violated the ethics laws, or more than that, whoever you are dealing with, the public employee or the public official, is accused of violating the ethics laws. In order for us to have any enforcement authority over that conduct, a complaint has to be filed with our office, a written complaint supported by credible and verifiable information. If that has been filed with us and the Assistant General Counsel, the General Counsel, and I have reviewed the complaint and have determined that it satisfies the basic requirements that the code requires complaints filed with us to have, then we will assign that complaint to one of our investigators. We have 5 of them. Statewide jurisdiction. They're from North Alabama down to South Alabama. They have full subpoena authority, full enforcement authority that any certified law enforcement officer has, and they will begin investigating the complaint. Once they investigate it, if they likewise conclude that there appears to be evidence supporting, or there is in fact evidence supporting a violation of the Act, then they will again present it to our Assistant General Counsel and the General Counsel, who will look at the evidence, determine whether they agree that there is evidence supporting a violation, and then they will present it to me. At that stage, I will review the complaint. I will review the evidence that has supported the recommendations of the agent, the chief investigator, the Assistant General Counsel, and the General Counsel, and I will either agree with them or disagree with them. More often than not, I agree with them, but not always. But if all of us agree that there is evidence supporting a violation, then we will present it to our commissioners, who sit as a grand jury of sorts and weigh the evidence, and they are tasked with determining whether it is more likely than not there has been a violation. Their standard is probable cause only. If they vote that there is sufficient evidence of a violation of the Ethics Act, then they will vote to either refer it to the Attorney General of Alabama, the district attorney in the location where the offense occurred, or they can vote to impose a fine. And we impose a lot more fines than we do anything else. We do have the authority to impose fines up to $6,000 for violations of our Act. But in a nutshell, that's what our enforcement looks like. Intentional violations of the Ethics Act are Class B felonies. They're punishable by between 2 and 20 years in prison. Other violations are misdemeanors, and then, as I said, we also have the authority to issue fines. But that's what that looks like if you're at the far end of it and you violate our Act and we're looking at enforcement. So make sure that you stay out of that. Well, how can you stay out of being in that land of violation? You can ask a question. You can ask it ahead of time. We also have a lot of guidance on our website for lobbyists, but again, I'm going to tell you that Vicki is the one you go to about the compliance issues that you will deal with daily. Now, Vicki's not going to be with us forever, but there will be another employee who will be just as helpful, who will be taking over when Vicki retires later on this year. Her name is Brianna Kelly. You'll meet her when you meet her, but she will be just as happy to help you as Vicki is too. I just know a lot of you deal with Vicki a lot, and she's a great resource. So I want you to use that. I want you to use the one that you're used to calling. And anyway, that is what our enforcement looks like. We have a timeline to resolve all these complaints. We have to resolve them within 180 days unless our commission gives us an extra 180 days to resolve them, but we've got limited jurisdiction and limited time to get these answered. I do think it's helpful for you to know what the enforcement provisions of our Act say, because the decisions you make do affect people. They potentially affect you because you can be held responsible under the enforcement provisions of our Act too, but those public officials you're dealing with can also be held responsible if they accept certain things that they're not supposed to accept or are prohibited from accepting under the Ethics Act. So it's, in some places, in some jurisdictions, it's violations are kind of a slap on the wrist. In Alabama, it's a criminal violation, and the penalties for that can be quite significant. The overall theme of the Act is that no public official can use or allow anyone else to use their position for their personal gain or for that of a family member or for that of a business you're associated with. The best example I can give of this is that if you were a public official, let's say you're an elected local member of the city council, and there is a measure pending in front of or an ordinance rather, pending before the city council that would provide a benefit to a business that you own, and you vote on that, that can be a violation of our Act. That's probably the easiest example Most people understand the term conflict of interest, and that's really what we're talking about here, is that somebody is using their official position, voting is certainly using their position in the face of a conflict of interest in a way that would benefit themselves. However, for lobbyists, there is one section in our Act, it's Section 5.1, that prohibits transactions between lobbyists and public officials or public employees and members of their family. It is a strict prohibition against giving a thing of value to a public official, and it prohibits a public official or public employee from soliciting a thing of value from a lobbyist. The definition of thing of value is gift, favor, benefits. It's everything that naturally comes up in the course of dealing with public officials. You're talking about, and bear with me a minute, I'm talking about the general prohibition, and there are a lot of exceptions to it. But anytime you're giving something to a public official, or anytime a public official or public employee is soliciting a thing from you, it's going to be under this general prohibition. So think about tickets to sporting events, or any kind of recreational event. Food and beverages technically falls under this definition. Offers of employment, other opportunities or benefits or favors. And again, typically what this looks like is something that has a price tag you can attach to it, something that is quantifiable in dollars and cents, something that has value. But the definition of thing of value is broader than that, and under the right set of facts, it could be something that doesn't have a price tag attached to it. But day in and day out, the issues that come up and that people really care about are things that do have a price tag that is either attached to it or could easily be evaluated and calculated in. Okay, now that's the general prohibition. And the prohibition is that you can't offer and they can't solicit. You can't give and they can't accept. Now, there's about 16 exceptions to that, which, breathe easy, cover most things you're going to want to do. If you want to give an educational function, there's a conference, and you want to invite public officials to it, you want to invite public employees to it, and you want to cover their registration. You want to give them meals that are an integral part of that event. You want to cover their rooms, especially if they're speaking, and it's part of their official duties. It's consistent with their duties as an elected official. All of that is allowed. There are meal allowances, separate individual meal allowances. If you're a lobbyist, you have an allowance of $25 an occasion with an annual cap of $150. Principals, who are the companies that retain or otherwise hire lobbyists, you have a $50-$250 limit just on meals. It's separate and apart from what may be allowed under an educational function or a widely attended event. And for any of you who do lobbying at the federal level, widely attended event and widely attended gathering under the federal system are roughly the same thing. You're talking about a collection of people. In Alabama, it's got to be at least 12 with a diversity of views expressed within the makeup of those who are invited. It's a pretty standard feature of ethics schemes throughout the country, but it's okay for you to provide limited things to participants in those kind of events. Economic development function is another one that lobbyists like to take advantage of, and it's allowed. If you have a specific good faith economic development objective you're hoping to achieve through the provision of food or whatever, then that is also an allowed exception under that general prohibition that I talked about. A good example of an economic development function, and I just point this out because it is so clearly an economic development function. In Alabama, at least, every year up until, I guess, last year, there was always an economic development event that state economic development leaders would participate in England. There was also the Paris Air Show. But aviation is a big industry in several parts of the state. And so we would receive letters from individuals, lobbyists, or others who would want to host functions at the Paris Air Show, or I think it's Farnborough, in England, and offer meals and rooms and all of that as part of it. And that we have said is an economic development function because the reason you're going is to highlight the area of aviation within the state of Alabama where that is a Okay, remember that economic development function. Let's hold it right there. We're going to go offline because apparently there's a fire in the building or some emergency or it's a drill, but I suspect we will be back in probably about 10 minutes, but hang tight. All right, we're on? Okay, apparently that was a drill only that we didn't get notice of, but welcome back. The other thing that I want you to remember in this same vein, there is a separate provision that applies specifically to lobbyists. It's the clearest provision we have in the Ethics Act, and it says that nothing can be solicited from a lobbyist, whether it's a thing of value or not. Y'all cannot be solicited for anything, period, except a campaign contribution. It is probably the clearest provision we've got in the Act. But remember that. So if you are being solicited to be a sponsor for something, technically that's something you're not supposed to be solicited about because it's not a campaign contribution. It is what it is. It's as clear as it can be, though. And if you were solicited for anything other than a campaign contribution, it is a violation of the Act by the person who solicits it, for sure. Okay, so if you have any questions about that, ask. You also have a de minimis allowance. Any item that is $25 or less has a specific exception that applies to it that makes it an exception to the definition of thing of value, but you have an annual cap of $50 on that. Where we see this applied a lot is with minor baseball. People will buy tickets for public employees to attend in conjunction. Maybe they're recognizing, I don't know, employees from the Department of Finance or the Department of Revenue, Motor Vehicle Division, or something. And so they'll have, baseball night at the local minor league field here in Montgomery. And those tickets are typically less than $25. And we've had people qualify those tickets as a de minimis item that we have recognized as being, allowed as an exception under the Ethics Act. So I don't expect you to remember every single exception. What I do hope you can remember is that there are a number of exceptions that in the normal course of dealing with public officials or public employees will allow you to do your job and also do it in a way that is not stiff or stilted. There are exceptions that seem to work pretty well in facilitating discussions between groups and public officials, and they are specifically allowed by the Act. So ask us about those exceptions because if they're there, we'll be more than happy to point you in the direction of where they exist. Okay, I've gone over that. And at this time, I'm going to turn the program over to Cynthia Ralston, our General Counsel, that will talk to you in more detail about these specific requirements that I've just gone over with you.
Hi, how is everybody? It's right there. Okay, so it is strange to just talk to a camera and our staff, but I'm Cynthia Ralston, General Counsel. So as Tom described, the 5.1 is a limitation on principals, lobbyists, and subordinate lobbyists giving a thing of value to a public employee or public official. There is a list of 18 exceptions to the definition of thing of value. These advisory opinions that I'm about to talk to you about are about those exceptions. So when you pre-certify an event, what you're really doing is asking the director to find that there's an exception to the definition of thing of value that applies to your event. So those are, and Tom's covered some of this, so forgive the duplication, but widely attended event, economic development function, and educational function. There's different things that can be paid for in each. Some of those overlap. And my clicker's not working. Okay. So a widely attended event is defined in our Act. It's a gathering, dinner, event, reception that's of mutual interest to a number of parties, and that you'll reasonably expect that there's going to be 12 people there. You can't just invite 12 people and that necessarily be considered a widely attended event. You would need to invite more than that, but it could be a very large dinner or it could be a large conference. So, because widely attended events can happen anywhere, as Tom just discussed about the Paris Air Show and things like that. Those can be outside of Alabama, but educational functions can only be inside Alabama. So, unless they are attended by mostly out-of-state participants. So, the educational function is exactly what you think of as a conference. You have an agenda, there's a formal agenda, there's different breakout sessions, people come together, learn about a topic, and go away. So that's an educational function. The economic development function, again, Tom went over this already. So transportation and lodging can be paid for the public official, the public employee, and their spouses for widely attended events and educational functions. So it's actual and necessary expenses. So you can't have a conference where everybody stays at the Fairfield Inn and Suites, and then the public official is staying at the Westin down the street. Everybody needs to be, kind of included in the same necessary and actual expenses. Also, unless the public official, public employee is actually participating or attending the event, they can't be paid for, if they're speaking one day, they can get a hotel room that night, but they can't be paid for 4 nights of the hotel room when they're not otherwise participating in the conference in any way, because that's not necessary for their participation in the event. So meaningful participation is they are a speaker or a panel participant presenting information related to their agency, performing a ceremonial function, and that it's appropriate for their official function. Economic development function, you can't have your spouses included in the actual necessary expenses for travel and lodging under economic development function. There's hospitality. So hospitality is what you think of as a reception or something that's not necessarily sitting in a classroom or a room and listening to a speaker. So it's food and beverages that are an integral part, such as a luncheon, banquet, reception hosted by an association, and spouses can be included. The hospitality, and I'll talk about this in a minute with an advisory opinion, but it can't be just fun on its own. It can't be just a deep sea fishing trip. That's not a widely attended event. And it's not really an integral part of the conference. That's really a standalone event. So we would not be able to pre-certify that. Food and beverage exception, Tom already talked about it, but the exception applies to the specific public official or public employee. Okay, so if a principal takes me out to lunch, or dinner, they can spend $50 on me, even if there's another lobbyist with them. The lobbyist can't then spend $25 on me. The number is capped at me. So I'm only going to get either 25 or 50, depending on who's paying for the lunch or dinner. And then they can only do that 6 times a year, totaling either 150 for lobbyists and subordinates of lobbyists, or 250 for the principals per year. So the pre-certification function is actually exception is actually a separate exception under thing of value, but it only applies to widely attended event, economic development function, and educational function. So we can't just pre-certify an event that doesn't comply with one of those definitions. Okay, so I'm just going to kind of put this up here. I won't read it all to you because you can read. But this is what they have to be. So you've got the event. You need to tell us what it is, whether or not it has all the requirements of the definition, the agenda, the speeches, and then concerning something that's important to them for public policy. So I go lecture on ethics. I wouldn't go lecture on accounting because that would not be helpful to anybody. And it would not be anything associated with my public position. Widely attended event, these are all, it's defined in our act, so you can find that pretty easily. And the diversity of views is important. So in a conference, though, when you attend I'll use accounting again, but an accounting conference, you might have 50 accountants. Just because they're all accountants doesn't mean they don't have a diversity of views. So those 50 accountants still have a diversity of views. So it's really just more than 12 people. Sorry, I'm having... Okay. And again, it can't be purely social. And we're going to need the list of the public officials and public employees that are invited. If it's under 50 people, we'd like a sign-in sheet and how many people do you expect to attend. And what you're paying for. Whether or not spouses are included. I don't know why this is happening. Spouses are included. What the transportation is. Is everybody else, everybody else is driving or... I guess if it's close enough, you're driving, but are you going to fly the public official, whereas everybody else is close enough to drive, and that sort of thing. So we'd need to know that information in order to tell you whether or not that would be an exception. And what is their participation? Again, you can't buy them a hotel room for 4 nights if they're only going to really be doing anything for an afternoon. Okay. This is really annoying. Okay, so, oh, sorry, and y'all could hear that out there. So the integral part, it can't be a standalone independent event. You can't take people on a hunting trip and that be an integral part of a widely attended event, even if the sponsor says, yes, I think that's a good idea. And the attendees, need to be people that are attending the event. So what you would think about is the dinner, a reception the night that the conference starts. So it's either at the beginning of the conference, at the end of the conference. The sponsor supports it or endorses it, and so that would be something that you would think about the hospitality. Okay, so this is you can't stack meals. That's what I just said, that I just described, that it applies to me, the employee. So you can't have 3 principals at a dinner and then they buy me $150 worth of dinner. I can only get $50. It's coming from one of them. but it's called stacking, so you can't stack those meals. You can't, as Tom said, also de minimis. We don't have de minimis lobbying. If you're being paid to lobby, then you're a lobbyist and you have to register. This is driving me. Again, 2011-11, also these can be found on our website as well. This is the one that said a sporting event or recreational events are not going to be pre-certified. And we had somebody ask this question about sponsors. If you have multiple sponsors for an event, they could aggregate. There can be limited aggregation. So that if you put all your money in a pool, and you're going to all be paying, that money's going to be paying for different things. Some's going to pay for hotel rooms. Some's going to pay for a dinner, maybe a hospitality, a conference. A reception. Then you can aggregate that, but we're going to need to know what sponsor is paying for what. So we'll just ask that information on the front end. Pre-certifications are one of those things that you can email us, and we're going to just follow up with several questions, and we need those answered before we're able to pre-certify. But as Tom said, the pre-certifications are put on our website. It's really cut down on the questions that people have out there. Public officials also like it because if they're invited to an event, they can just go on our website and see if it's pre-certified, and that they're not in any danger of violating our act if they go to the event. It does have to be more than 10 days ahead of time. If you ask us after 10 days, we can't pre-certify it because we have an administrative rule that says we can't. So there was a lobbying question. There's a statute 3625 1.1 that is referred to as executive branch lobbying, but it expands the definition of lobbying. So there is an exception that says if you're selling goods or services that you are not a lobbyist. But in 1.1, if you are doing that for the state, you are a lobbyist and you must register. And so we gave that opinion to Al Agricola in 2018. Okay, that's our website. We need to get a new graphic of it, but that's our website. It's updated a little bit. And Tom has parting thoughts, I think. And thanks. And what you need to know is you always can call us and talk to us. We give advice every single day. We get probably 5 informal opinions a day. So just don't get in trouble. Just ask us.
Okay. This is, if you're going to screenshot anything, screenshot this because this will make your job so much easier. Remember to update your registration within 10 days. I tell you that for your own convenience. If you take on a new client, if you change who you're lobbying for, update our office, contact Vicki, and you must update your registration within 10 days. The reason this helps you is that if you are actively lobbying for somebody you have not registered with us to lobby for, somebody is going to point that out to us, and they're going to want us, generally a competitor of yours, is going to want us to do something about it. So it would help out things enormously for you if you will remember that 10-day requirement to update your registration if your registration changes at all. That includes who you're lobbying for or the subject matter you're lobbying. Communicate with your principal. You would think that this would occur. It doesn't always occur. But if you have registered as a principal, as a lobbyist, but your principal, the person or the business that has retained you, and that's who the principal is, has not confirmed that you are their lobbyist, then it's not going to show up in our system as you having registered as a lobbyist. We've got to have that confirmation that you are the lobbyist before it can appear on our website. Now, Vicki's been working here a long time, and Vicki knows who is generally lobbying for whom, and she knows when the principal is likely going to get their confirmation in. She will gently remind you, principals, that you have to confirm the registration of the lobbyist. When Brianna takes over, she's not going to have that same wealth of knowledge. Be that as it may, if you will contact and coordinate with your principal to make sure that they are confirming you, then it won't be a problem for anybody. I just want you to stay out of the crosshairs of people who might want to make an issue about that. And every single session, somebody calls over and says, so-and-so is over here lobbying and they haven't registered with you. To the person, I have gone to Vicki, or Vicki has brought it to my attention, and she has said, the lobbyist has registered, the principal hasn't confirmed it, but I know they will. This principal always confirms the second week of, I don't know, February or whatever, but she knows their patterns. However, that lobbyist then has to explain why they're registered and why they're over there lobbying the legislature, and it would just simplify things if you make sure you're coordinating with your principal. Remember your quarterly filings. You have to report certain things. Any transaction that you've got with a public official or public employer, a member of their household that exceeds $500, or any expenditure in excess of $250 in a 24-hour period has to be reported to us, and it has to be included in your quarterly filings. If you are hosting an educational function, and even if we have pre-certified it, but your room, the meals you're providing, all of that adds up to more than $250 in a 24-hour period, you have to report that. Make sure that you are reviewing the quarterly report yourself before it is submitted. We have had occasions where lobbyists have submitted a report that was inaccurate, and when it was pointed out to them, not by us, but by a member of the press who is going over the quarterly reports and wants to know why you haven't reported the rooms that you paid $250 for a night or more for a public official, why that wasn't on your quarterly disclosure, you then have to sort that out. And it's not uncommon that somebody will say, well, I left it to so-and-so in my office to fill that out. They made a mistake. We're going to update. Again, I just want you to avoid that drama. So look at the quarterly reports and make sure that they're accurate. Eyeball them yourselves. So remember your registration, remember to update it, communicate with your principal, and review the things that you're filing with us yourself to make sure that they're accurate. Remember the 10-day rule for pre-certifications. If we do not pre-certify an event, remember it doesn't mean that you can't host the event. It just simply means that it goes without our approval. This still throws some people off, though, when it doesn't get pre-certified, because it creates the impression that there may be something wrong with it. If you submit it to us on less than 10 days' notice, an administrative rule prohibits me from pre-certifying it. I can't do it. So just remember, and especially if you're new to this, remember that 10-day rule. Set it on your calendar when you have to request pre-certifications. There are people who will request pre-certification 6 months out. You can certainly submit it then. I'm probably not going to pre-certify it that early unless it's the kind of event that you need 6 months lead time to know whether you can do it and whether you can invite public officials. If there's not a time crunch on it, then certainly 2 or 3 months ahead of time is the period of time that that we are used to pre-certifying events. The reason that I don't pre-certify them too early is inevitably the event changes, and so we will get calls saying, hey, we've decided that we're not going to offer this anymore. We're going to offer this in addition. What do I do? Can I just amend my pre-certification? I tell them just to go ahead and resubmit the application for pre-certification so that it can be contained in one document and we know exactly what they're doing. The other thing to remember about pre-certifications is if you have it pre-certified once, that does not pre-certify it for all time. If you want to do the same event next year, you have to request pre-certification again if you want it pre-certified. The reason we do that is because events change. More than that, though, personnel changes, and I don't want new personnel changing the event and assuming that it's been pre-certified because we pre-certified it 2 years ago, 3 years ago, 5 years ago. So every year, if you want it pre-certified, you should submit it for pre-certification again. And remember to ask questions. That's the biggest takeaway. Ask questions, ask questions, ask questions. I spoke somewhere today and said earlier today and told them the exact same thing. Ask questions, ask questions, ask questions. And somebody said, do you charge for answering those questions? The answer is no. Everything that we provide free of charge, so you can ask away. And I think we're actually pretty good about being responsive to that and responding pretty quickly. I have not heard a complaint about our responsiveness to questions that are important to you. And I know the people who work for me, and making you happy and making your job easier is important to them too, especially in this area. So be sure to ask questions if you are in doubt at all. And just know that we're here to help make your job easier and help you stay out of trouble. So I appreciate your attention today. Right in a little under an hour, so good for y'all, but thank you for paying attention. And good luck to you. Y'all have a good rest of the summer.